You can actually feel the defense trying to paint a picture of someone who did everything right after the mistake. No violations, completed treatment, followed every rule, and still, it's not enough. And that's where this case starts to get uncomfortable, because it raises a real question. When does doing everything right earn you a second chance?
Wanted to put it in front of the court. And then alternatively, Your Honor, if he was to be denied, I advised him that he could always pursue this again in the future. And we would ask the court at that point for some other modifications of his current probation.
But then the state steps in and brings it back to reality. This isn't about effort. It's about timing and the law. And legally, they're right. He hasn't even reached the halfway mark. So now we're stuck between two truths, someone trying to rebuild and a system that moves on its own clock.
Probation at this point, Your Honor.
All right.
Your Honor, may I add
Sure.
one more thing? Mr. Burnett has been laid off. He is looking for a job. It's not just that it affects his ability to go enhance his career. He needs to go find a job, and therefore, that's really what prompted this. Is this need to find a job.
Okay. So what is precluding him from finding a job?
I'll let Blake answer that.
So when he's applied, Your Honor, just for the things I've stated before, when he has applied, and he shared these things with the probation department as well, but he, when he applies and they do a background check, it's not that he has this on his record that's precluding him. It's the fact that he's actively on probation, and that he has to travel domestically, interstate, for bulk of his work and internationally in the medical and pharmaceutical sales business. He was doing quite well up until this tragic case, and which he did accept his portion of responsibility for. I don't know if Your Honor remembered the facts of this case.
Yes.
Okay, and so that's that he's being told by them exactly what's going on, and the fact that he is going to be obligated and was in his prior role taking CEO, Alphabet officers out for, the schmoozing, the dinners and the meetings, and he can't rent a car to go pick up the clients at this point because it requires him to have ignition interlock everywhere he goes. So it's both the background, them running his background and seeing he's actively on felony probation or deferred, and coupled with the fact that he is restricted in his ability to rent vehicles that are without ignition interlock.
This is the moment that hits the hardest. The judge isn't just denying the motion. She's explaining something deeper. Consequences don't disappear just because you've improved. And what really shifts the tone is when she brings up the victim of fractured pelvis, a life permanently changed. That's the part we don't see in most redemption stories. Growth doesn't erase damage. And the line about working any job, even something you never imagined doing, that's not just advice, it's reality. It's humbling, and honestly, it's hard to argue with.
I'm not willing to do that at this stage.
Okay.
Right.
And the other thing we were contemplating was, can we switch him to report by mail or pro forma? Since right now all he does is check in.
No.
So still monthly in-person visits?
Yes.
All right, Your Honor. Thank you for taking.
All right. Thank you, Mr. Moore. I think he wants to speak with his attorney. Just 1 second. The attorney, I should say the attorney that's in court.
Yeah, thank you, Judge, for doing it this way. I'm actually picking a jury in an hour, so.
Oh,
Yeah.
wow.
Mr. Barnett has come several times to ask for permission to travel out of state in order to look for jobs. And when he worked, traveled to work. Can we lift the state injunction to go travel out of state for work?
He needs to, 1, a motion will need to be filed. 2, he'd need to provide proof of that to the court. Then the court will consider that.
Thank you, Your Honor.
All right. You're welcome.
Thank you all. Nice meeting you.
All right. Thank you. Good luck with your trial.
All right. Thank you.
CR 2668, State of Texas versus James Errol Bradley. Can I have parties announced for the record for the state?
For the state.
Defense.
John Pettis for defense.
All right. And are you Mr. Bradley?
Yes.
Counsel, have you received all the discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Bradley, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We're proceeding on a lesser included charge of assault, bodily injury, family, household.
Any objection?
No objection, Judge.
Showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, family, household?
Yes, ma'am.
That is a Class A misdemeanor. The range of punishment, if you all can initial here.
Yes.
The range of punishment is anywhere up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
Guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Judge.
All right. State, was the complainant informed of this offer?
Your Honor, this complainant previously tendered an A&P to our office, and in subsequent attempts to contact her, she's been unresponsive and the state's been unsuccessful in making contact with her.
All right. Anything you want to say on behalf of your client?
Judge, I would just like to say that
And just like that, it's denied. No early exit, no shortcuts. What stands out is that the judge did listen, but listening doesn't always mean agreeing. Sometimes it just means you get a clearer explanation of why the answer is still no.
Then that's what he will be doing. And he will be taking that into his school years. Do you have any?
This second case shifts everything emotionally. Now, it's not about career or probation. It's about a child watching violence at home. And the judge breaks it down in the simplest, most brutal way. Kids learn what they see. That idea that a child might grow up thinking love equals harm is honestly one of the most disturbing parts of this entire video.
Going to have to move on to somebody else. Do you understand?
Yes, ma'am.
If you have contact with them, it's going to show up in the system if the police are ever called and there's going to be an issue. You understand?
Yes, ma'am.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because this is an affirmative fighting of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. And because this is a plea bargain agreement, I follow your plea bargain agreement and you waived your right to appeal. You do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. I mean this and hopefully the most helpful ways for you. And I don't take domestic violence lightly, but if you want to be in a relationship,
The no contact order feels final, not just legally, but personally. Whatever relationship existed, it's over. And even if the victim wanted to go back, the court is stepping in and saying, no more.
you have worked towards making that bloom. You understand?
Yes, ma'am.
Do better.
Yes, ma'am.
And then the orchid analogy. It almost feels out of place at first, but it actually ties everything together. Patience, effort, growth. It's not instant, and it's not easy. The message is simple. If you can't take care of something fragile, you're not ready for something serious. And honestly, that might be one of the most real pieces of advice in this entire courtroom.